Welcome, everyone. Thanks for taking some time out to join us on this webinar today. I've got with me Keven DuComb, one of our attorneys at Hargrove Firm, and I am Alex Hargrove. I'm the CEO at NetLaw, and we're going to talk a little bit about what NetLaw does and how NetLaw makes it really easy to work with the Hargrove Firm in all 50 states and how to scale those services. And then mostly I'm going to let Keven talk about things with legal substance, things that impact how you're talking to your clients and the kind of recommendations you're making to your clients around estate planning. A little background on Hargrove Firm and NetLaw. So Hargrove Firm was started by my father, Jamie Hargrove. He was the head of trusts and estates at an AM 200 law firm and quit big law, wanting to start an online law firm. We actually have two companies, as you can see on the logos behind Keven and I. That's NetLaw and Hargrove Firm. And the reason for that is really regulatory in nature. In order to raise the sort of money we had to raise to build and scale the technology platform we would need to power the legal services in all 50 states, we had to access the capital markets, and that's something law firms can't do. Only lawyers can own law firms. So you end up with a structure where you have a law firm that's supervising the delivery of the services. It's always going to be the law firm. It's always going to be Hargrove Firm that you're referring your clients to. You're never going to refer your clients to a technology company that might introduce them to a lawyer at some later point in the process. And as part of that, your clients are always going to meet with a licensed attorney from Hargrove Firm, both one of our lead attorneys like Keven, as well as an attorney that's licensed in the client state. And those meetings are always going to happen with your lead attorney on there with that local counsel. So the client's never going to be handed off to some attorney that's in some network in some state. It's always going to be led by your lead attorney, somebody like Keven that's got 5 to 10 years experience in a complex planning environment. In Keven's case, that's graduated from a top 14 law school that carries a lot of clout in the legal industry and has worked both inside the plan design function at an RIA, inside corporate trustee, as well as in private practice. So what you get out of that is a really easy way to access a law firm that's going to provide your clients with sophisticated advice across all 50 states and take responsibility for that advice, malpractice insurance, and that sort of thing. So it's both the work product and having a law firm that's willing to take responsibility for both the work product and the advice it gives. So with that, Keven, why don't you give maybe an overview of your meeting with dozens of advisors every month, the pitfalls you see for advisors, and maybe a little bit on the advisor's role you see, the role they play with their clients in the meeting, or maybe the role they should play.
Yeah, no, absolutely. Thanks, Alex. And that's exactly where I'm going to go. I don't think the pitfalls are going to be all that earth-shattering to our attendees, but I think our approach to it, the way we try to incorporate these discussions and address them and really work together as a collaborative team to get the best result for the client and really a durable, long-lasting result for the client, I think is kind of what we want to focus on today. So it's a fun topic to kind of start with things that go wrong and then sort of dovetail into how we do it right and how we solve these problems. But yeah, I'll just kind of jump right into it. So really the first three, 1, 2, and 3 here, I think go somewhat hand in hand. They're all generally under the guise of someone did a plan, but they didn't really actually finish the plan by getting assets in it, or they did something else with their assets and they didn't know it was going to supersede what they were doing with their plan. But we kind of broke them up because as I go through sort of the case examples in each one of these and sort of what we're seeing week to week, like you said, Alex, I think that you'll kind of see that they do tend to manifest a little bit differently. And that's kind of the way we're looking at them. So this first one, I think we've all probably seen it. The beneficiary designations just don't make sense anymore. They were done 20 years ago and they were never looked at again. I think certainly we always heard marriage, divorce, new births, deaths, all that sort of thing. I will say divorce we're seeing less and less. I think in one case, the attorneys that walk through divorce proceedings do a good job of trying to bring these things up and helping people change them. Some of it's asset type in nature. We have a lot more qualified accountants these days. People on the call may be familiar with the quadro and some of the official paperwork they actually have to walk through to move or transfer assets between the spouses. And so I think there tends to be a little bit more focus in the divorce side of things and getting these things updated or at least removing X's from accounts and things like that. Also, more and more states have added a default statute that says even if you leave an X on an account or a beneficiary designation, that it will be considered void um, by default, just on the assumption nobody did want to leave their X in there. And you almost have to jump through hoops if you actually did want to, for some reason, leave the X on the accounts. So that one I think we're seeing a little bit more clarity on. But in some of the recent conversations we've had, we've seen some more issues around children. Um, I saw an interesting case where it was more like an estrangement scenario where they had, kind of done the default. I'm going to add all my kids as co-beneficiaries on the account. And then as we were going through the conversation and revisiting this, they kind of brought up, I actually don't really know where that child is or really what their life looks like. And so having that conversation about, hey, that's a great segue into why we like to bring a lot of this into the trust, why we like to address a lot of that stuff at the trust level, keep it private, keep it out of court. And here's a great opportunity where we're going to change that beneficiary form to really divert it all into the trust. And then we can have those conversations about different allocations or even, the quote unquote disinheriting a child or whatever the goal ends up being for the client. So that one was kind of an interesting take on this problem that I think we see fairly often. Um, kind of go into the next one. Like I said, I think these first three all kind of are in one general group, but inconsistent asset titling. So again, the idea that um, people did the trust planning, but then they didn't fully understand the funding process, that they may have changed things over the years or didn't fully remember to go back and talk through it with either your team or because you're a new advisor, in the lifespan of their investment history, whatever it may be. There's just things that kind of get distorted over the years. Certainly, one of the things we see valuable in working together and as a collaborative team is that hopefully we're going to catch all of these things moving forward. We're going to keep it at the forefront of your annual meetings and know that you can always kind of reach back out to us, just touch base and say, hey, they want to do this different account type or they want to move assets this way or that way. How is this going to still coordinate with the plan? And we can kind of have that conversation. Um, this particular one, I saw kind of a very interesting example recently where um, it was a blended family second marriage situation. It really was stark because they had a lot of real estate. So it appeared that maybe in the previous relationship, the client had started developing a real estate portfolio. There was a divorce. They kind of kept some of the assets. They got into a second marriage situation and they sort of continued to expand the real estate. And so with deeds and stuff that was really, really concrete to see, we started to realize that one, they kind of forgot that all the previous properties were still in this
E.
original single grantor trust that the one client had created during the previous marriage. They had purchased some new property as joint with right of survivorship. I think in one case they had actually deeded a new property to the old trust and then thought somehow it was gonna still, go to the new spouse if something were to happen to the grantor spouse. And so it really just kind of hit us that wow, this is a great example of probably other, maybe less uh, concerning scenarios where this plays out, but probably something that actually happens more than we realize. And so, it's been kind of an eye-opening experience to walk back through and just guide them through. All right, we really need to move all of these deeds over to what we ended up creating, basically a new joint trust. It was community property and some other reasons to do that, and ultimately kind of aligned with their goals. But that one was definitely kind of an interesting
And
one to come
and wow, if you're the advisor that helped a client find out that one of their assets was going to their ex former spouse, you're the hero of the day. That's for sure.
Yeah, and I think luckily it wasn't even all that draconian. It was maybe just going to go to children as opposed to the new spouse, and the goal, of course, was to provide for the new spouse. But yeah, no, I mean, absolutely. I mean, it could run the gamut, whatever those terms of that original trust were, and they weren't really
Be surprised. Yeah.
side of things. Um, um, so yeah, no, it's definitely kind of a version again. Maybe it's funding, maybe it's time, but I think in this case it really was just not recognizing the value of having to kind of morph your plan a little bit and then really kind of coordinate your assets. I think this also goes along. We've seen actually an uptake in some examples where, particularly again in community property states, second marriage, where they actually do want to plan for some joint community property, but at the same time they've brought separate property to the marriage. And so we've had a few different instances where we've been creating really three trusts, right? So we have kind of a joint trust, community property. We actively put some assets in there. And then we've got two separate trusts that they still use to manage their separate assets and have completely different sets of beneficiaries there. So, it's interesting. In theory, you probably could try to do that in a joint trust and you could use different schedules. But you want to talk about something that can get really messed up really quickly, and someone doesn't update the schedule, and now it's considered to be part of the joint as opposed to part of the separate. We've really seen some of those instances where it made a lot of sense to separate them out and kind of track them in their silos, so to speak. So yeah, some definitely some interesting stuff along this asset titling line that we've been seeing. Um, Kind of moving over, again, I think three is maybe phrased in the most generic or common way we see it is just no funding at all, right? We still regularly meet with clients that are looking to update a plan, and one of our first questions is, did you actually fund? Are there assets in your trust? Are there accounts in your trust? Did you move real estate? And either that's part of the reason they're coming to the table. They kind of just say right up front, no, I never knew I was supposed to do that. Nobody ever connected the dots. Again, a huge part of what we're trying to do here in working with the advisory team is making sure that we have that conversation from the get-go and that we all know kind of our role and responsibility, and making sure we get everything buttoned up once the documents are signed. But it's one of those things that it's still pretty amazing to hear how many people spent probably even more money on that plan than they might be spending on this plan and never actually funded it or really had anything in place that would have carried out their wishes as they thought that they had set it up. Um, in this particular realm, too, I think what we're seeing a lot is the coordination of the LLC and being able to have that conversation. That's even really something you might have some clients where you feel that they've got a great plan in place. They work with a really reputable attorney. You've referred to that attorney many times. You know that those documents are good. They've funded everything else that manage in terms of AUM accounts and real estate and things like that. But they did kind of a side gig LLC or something that they sort of did on their own. Nowadays, I think more and more people are aware that it is very easy to just go online to the state website, file the articles of organization. You got an LLC, maybe you open a couple of bank accounts. Maybe it's for a rental property or again, some sort of just kind of side gig online business or whatever it may be. And they may never have really brought it up, right? They may just kind of be running on the side. It's not related to an account you manage, and it can kind of fall by the wayside. But depending on what's there and what value they've grown inside of that asset, this is really something that can accidentally trigger probate inadvertently, because in 99 out of 100 cases, if they went and did it on their own, or even if they did it through counsel or some sort of DIY product, they probably own it in their individual name. And it's as simple as that. They often do not coordinate it with the trust. Maybe it was done at a different time than the trust or with different people, like I said. So in most instances, it is going to be a probate asset if we don't kind of come back and coordinate and make sure that that's properly funded into the trust. So I think this is something that we've really seen just time and time again, over the last several months, that there's these little LLCs out there, and the paperwork's pretty easy to do when everyone's aware of it and we know to kind of address it right off the bat. But when you forget about it or don't discuss it at all, we can really run into some problems when we get down the road and then we don't have the chance to do it. So again, kind of a fun wow case that I had where I think at last count we ended up finding 12 or 13 different LLCs. They had a variety of rental activities. There were even some kind of companion activities that they had siloed each and every last thing in an LLC. Probably a lot of crossover between the two, but they had bank accounts and some and this and that. And then, they were sort of hit with a terminal illness situation and said, "Oh, hey, I think we should probably get this all organized now." And so just trying to walk through that. There was nothing out there that suggested anything other than they owned it all in their individual names. And so we sort of had to kind of rush through that funding process on the LLC side to get it all squared away. So, these are definitely lurking out there, and they're something that we're seeing more and more. Yeah, go ahead.
We got a question, Kevin. I think you were just addressing the first part was about probate issues of closely held businesses, and then is it worth the trouble of retitling shares and member interest, partnership interest into the Rev Trust? And I think you were saying yes, it is worth it, but maybe a little more on what happens if you don't.
Yeah, no, I mean, I think it's clear what happens if you don't. Is just it's gonna likely be in probate. Now, it could be a version of is there a low enough value? If it really was something more just for organizational or hobby purposes, maybe there's not a ton of value. But I think more and more, it's certainly if they ended up putting any
Mhm.
real estate in there, it's gonna be significant enough value to trigger probate. So
And if it's in probate, what's the bad things there that happen? Maybe some people say my state has a probate process. They've modernized it some. What does that mean?
Yeah, I mean it's always possible you get the fastest judge ever and everybody knows what to do and they all understand all the forms to file or they have an attorney that's willing to do it, very low cost or whatever it may be. But more often than not, we are talking about a illiquid or non-easily valued asset. So in all likelihood, the sticking point is going to be you get to court, you file the paperwork, and then the judge wants proof or some very formal
Hmm.
appraisal of the value because part of their checklist is they've got to say this is the value of the estate. And in many states, that also means that's the fee that we apply a percentage to pay the probate fee. So, in a lot of cases, it's just going to be some sort of delay coupled with some sort of extra fee that would have been really easy to avoid. Because I think maybe the other part of that question there, Alex, was just that often we can do something as simple as even really a TOD like form. Many states now do allow really a rider to the documents that's like a TOD that basically just says this LLC is owned by me. I'm going to manage it, and hopefully everything goes well, and I wind it down and close it and sell it and do whatever well before I pass away. But if something happens to me, it kicks over to my trust. My trustee will take over. They'll figure out whatever they need to do to wind it down or liquidate or transfer the underlying assets over to beneficiaries, and then it stays out of court and everything is a lot more streamlined. So, the solution is so easy here that we really do want to highlight it as often as we can. In some cases, we do an assignment over, and it would then be them as trustee owning it. Once in a while, that can create a little bit of headache around. Now they got to go back to the bank and maybe they've got to have some different documentation because it was them individually. Now it's them as trustee. Again, these are Rev trusts, so there shouldn't be too much of a hurdle there. But anything we can do to kind of keep it simple, again, if we can use the TOD and just have it in the background so that it's ready to go, we're happy to help clients with that.
That's great. And we had another question, Kevin, about how you handle, I guess, what we're talking about titling digital assets like someone's Facebook or LinkedIn account or Instagram or even their Gmail.
Yeah, no, it's still an evolving area. I actually meant to highlight that as an area where there can be a lot of lurking value. I mean, nowadays, if you do have someone doing like influencer type activities, to you and I, that's simply an Instagram account, but it could be valued at significant sums. So again, if it's just in
Hmm.
their name, that's likely going to be a probate asset. So, at the threshold, we're always going to have in the language in all of our documents. So there's language in the trust, there's language in the will, and there's language in the financial power of attorney that gives carte blanche ability to manage or reach out to the custodians and say that you do have authority to either take control of transfer, close, whatever it may be for any of the online accounts. But this is a nice segue, and I'm going to bring it up in a couple more slides. There are things that we don't know what we don't know until the advisor tells us. So please bring these things up because it's very likely that we should do some more intentional planning for that specific asset rather than just saying, hey, your trustee has authority to access your digital assets and then kind of do whatever. You may very specifically want to allocate those accounts to specific beneficiaries or potentially even future business partners or whatever it may be, just to keep some of that running. And again, if it is deriving income or tied to marketing activities or whatever it may be, you probably do want to transfer it to someone very specific so that they can then continue or do something to extract the value back for your beneficiaries before kind of closing it or handing it off. So you got to tell us, you got to bring it up, you got to let us know. And then we can also just have that conversation about some specific provisions in the trust that will transfer or address those assets head on.
Yeah, and you can about guarantee these things aren't happening if you're referring a client just to a local law firm and they're sort of a black box, and you check in a few months later and the client says, I got my estate planning done. That's where the ball gets dropped. That's why, our platform is built around making sure the advisor is involved in the process, because this area, I think in particular, is where their assets, the client's financial plan, and it takes you working together with the estate attorney to be able to ensure all this is coordinated beyond just having the documents drafted.
Yep, absolutely. So kind of jumping up, this is I like to say I still think we need to have a contest or something, Alex, but I personally have never seen someone do it right. I've seen several examples of people having omitted really odd things from their estate plan by doing a DIY product. Um, in one case, they interpreted the question, where do you want your assets to go, as I want it to go to my kids. They just assumed it was going to go to their spouse. And so in the actual document, they disinherited their spouse. The question was answered, I want everything to go to my kids. And so that's what the document did, right? It just skipped right ahead to the kids. And then in another example, I forget exactly how they thought they had figured it out, but basically they had a power of attorney with no agents. So it just said, I'm the principal and here's my power of attorney. And nobody was named at all to serve as agent. So however that happened in the system, it kicked it out that way. So those are some salient examples. I've seen a couple others. Fair, I always say probably I'm the one seeing the problems because somebody's realizing they need to get it fixed, and now it's time to work with an attorney. So maybe there's
Mm.
plenty out there that worked great, and I've just never seen them. But I'd love to see somebody have done the DIY completely right. The other side of it is, even if the document spells everything out, I think it's all the stuff we just talked about, right? It's okay, they did a plan, great, but they never actually funded or coordinated any accounts whatsoever into the plan. They probably are just using beneficiary forms that are going to transfer completely independently of whatever they defined in their trust or will that they created. And again, they may be under the opinion that, oh, that's the backup, right? A lot of people think my will and trust is going to be the primary document. And so if I just do these other beneficiary or TOD forms, that's just as a backup. Um, so, I think again, right, it's a big part of what we're offering here. Sometimes we do get lumped in with, oh, you're a virtual practice, you're online, it must be like trust and will or something like that. But of course, our big value proposition here is, nope, this is like going to the attorney down the street. We're going to sit down, we're going to have all these conversations, we're going to run through all these pitfalls and have, backup conversations and reiterate all of these things to the client, that it's important not only to
Yeah.
sign your documents but fund them and maintain them over the years and reach back out and work with your advisors and everything that goes into making sure that these things are actually going to operate smoothly.
And we're going to take responsibility for it, right?
Yeah,
At the end of the day, if something's wrong, the heirs sue somebody. They're going to sue a law firm here. They're not going to go after the advisor that helped them walk through a do-it-yourself tool.
exactly. um Joint accounts, in one way, this ties a little bit to what we started with, but this one often is a little bit different. It's usually that tried and true conversation about, well, someone told me that there's no way my kids would have access to funds if I don't make them a joint owner of the account. They're gonna have to pay for my funeral, and I'm trying to help them out. And I didn't think it mattered, whatever it was gonna go to my daughter who was helping me out. But we've seen some pretty stark uh, examples of a brokerage account getting listed to one child as joint owner, or something like that, because there are more DIY, or I guess what would be called retail investment options out there, where the client is filling out the paperwork, so to speak, and opening the accounts, and has a little bit more control over than they used to when they, had to work with a broker, or there had to be a financial intermediary somewhere in the process. So just trying to help people catch those things, have those conversations, making sure they don't do that going forward. And then just kind of having the conversation about why, your successor trustee designations and things like that are important. That's who's going to be able to kind of pick up and keep moving forward. They'll have access to the funds. They'll be able to kind of get those final expenses paid as part of that initial administrative process. So just again, a lot of education here, a lot of just allowing the clients to come to us with their real world questions and examples and just sort of walk through or stress test, if you will, kind of the plan and how it's going to work. Um, I think the other thing here, and this can relate certainly to beneficiary designations as well, but we've also seen great examples where we can have that conversation once the client is comfortable and understands that things like joint accounts or things like beneficiary designations and TODs will divert assets away from the core trust or will-based estate plan. And now we can have a conversation about why we might want to do that and why it's a good idea to do that. So the most classic example is still IRAs, qualified retirement accounts. They have charitable beneficiaries in mind. And we actually have either segregated part of their account that they only name a charity as beneficiary on that account, and then everything else comes back into their core estate plan. Or maybe they name a charity as a part beneficiary, and then the trust is the remaining beneficiary on the account, however they want to design it. But now that we've had the conversation, they understand the distinction between joint owners automatically receive assets or beneficiary designations supersede the trust. We can start to build it into the plan in a helpful way. And so that's the other way we've kind of approached some of these conversations is, yeah, there may be a really good reason to do it that way. And let's talk about that. But we want to make sure you start with the understanding of this is going to go outside of your trust if we do it this way. And is that okay? And is that why we're doing it? Rather than them just kind of having different things in different buckets and not really appreciating that.
Kevin, we've got a question going back to DIY again about whether you can give an example of how clients using DIY with an online tool, even if they did it correctly, resulted in a situation that you needed to deal with.
Yeah, I mean, I can't think of one off the top of my head where it was just about funding. But I know there's been some conversations or some of my colleagues have had that experience where, again, the document itself may say, everything to my spouse, everything to my kids, and that's what they want, and that'll be fine. It's just that in their actual account paperwork or documents, that's not really what they had, or they didn't bring it into the trust. So there's still a funding problem. There's still that gap between I
Even
have
when it's
a
done right.
statement over
Yeah.
here, but I actually am not coordinating anything at all. Certainly the real estate component. So if anyone's done DIY planning and then they didn't do a deed, they're gonna have a probate case, right? Their real estate is out there in their name, or eventually one spouse will pass away, it'll be in their name. And then it's not gonna go through the trust. And again, they may have just thought that. I think a very likely scenario too is a lot of times those DIY trusts will have the schedule, and some attorneys do use that schedule at the end that says, I listed all my property. Actually, I take that back. It's been a while. This was maybe, January or February, but I actually do recall a case now where there was a DIY trust where they had just simply listed everything at the end of the trust. And then I asked, oh, did you fill out the paperwork with your custodian so that it's in the trust and that? And so they were trying to say they wanted like certain percentages of certain accounts to go to different beneficiaries, and they wrote it all at the end of the trust. And then I kind of said, well, nothing's in your trust. You just have individual accounts with no, and I think they had no TOD or any beneficiary designation, because they were sort of like, oh, it'll flow back in. But then that's not actually what they had written into the document. They just sort of tried to
Hmm.
do it as an appendix saying, these are the assets I intend, and I want this asset to go to this beneficiary and this. And it was, yeah, that's not how estate planning works, unfortunately. We need to first get everything in, and then from what's in the trust, we can allocate different percentages, different assets, however you want to do it. So we had to kind of work backwards from what was basically just a handwritten or what might be called holographic will.
Thanks.
Um, the sixth one, again, I think we are all familiar with just simply there's no guardianship or we're naming minor children. I have no other choice. I actually met with a client literally this morning, single parent, minor child. So yeah, you're gonna name your kid as your beneficiary, right? Who else are you gonna name? So it's really about kind of having that conversation of how do we put more control, more organization in place, and make sure that you are actually getting a voice at the table if something does happen to you. Um, so some of it is we really do like to have that conversation with the clients and explain that, guardianship is more of a recommendation or a nomination. It doesn't guarantee the court is going to say exactly the order or the main person that you named. Some of that is because you may have done this 5, 6, 8, 10 years ago. And so part of the question for the court is if you did that when your child was 3 or 4 and they're looking at it because the child's now 14 or 15, it's going to be a very different conversation about what's in
Mm,
the best interest of the child. So we do want clients to really appreciate that there's still a court component when it comes to the guardianship side of things. They have to have that determination of the best interest of the child. And that could be very different even just within the 10 years from, very young child to kind of teen years. Um, we have some clients where they've got, a 16, 17-year old, and then they've got kind of the 20, 21, 22. It actually is perfectly fine. You can recommend that the sibling become the guardian for that just 1 year, maybe, if something were to happen. And so that's again a very different conversation. We're certainly not naming siblings when it's, a 2-year-old or a 3-year-old. In most cases, you're going to name maybe your own sibling, I guess, sibling still in the mix, but an aunt, uncle type thing or a grandparent. But yeah, we do actually have some scenarios where it makes a lot of sense. Um, and then I think that dovetails with a really important thing to consider here, which is sort of if you want to provide real estate or a home in the mix, how do we kind of coordinate that? That's something we got to kind of deal with through the trust. And we might even need to define that a guardian is a permissible occupant of what would otherwise be a trust owned property benefiting just the minor child. But we might want to define that in this scenario, we actually believe the guardian might move in with the child from wherever they live rather than us just selling that property and using the proceeds to help care for the child. So there could be a conversation there about wanting to coordinate where does the child actually live? Is it going to be an asset that's actually in the trust and just making sure we have that conversation and language updated. But otherwise, it is just kind of understanding that it is a process where you really have to consider a variety of different factors, and there may be a reason to update it. I think this is one of those areas a lot of people think I did it when they were 2, so I'm good till they're 18. But again, there may be a reason to revisit it when they're 12, 13, 14. Certainly, if you've also moved over the years, it could be a very different prospect from what you originally thought when you were protecting them as minors. Um, so yeah, no, this is a kind of an interesting area. It's something we can't fully guarantee is one of the things we like to emphasize. Another last kind of point here too is we do often see people naming couples. It's the idea that I want my child to go to Aunt Sally and Uncle Tim, right? Well, who's the actual relationship here? What if they break up, or what if something happens to one of them? Is it that you really wanted it to be Uncle Tim no matter what, even if he's remarried or some different situation played out? Or, did you kind of consider that? Because anything you say that can introduce some ambiguity into this process, going back to the fact that a judge is going to review this and talk about it, is only inviting people to fight about it, right? Because if Sally and Tim are still listed and they live in 2 different states and they're both coming and saying, yep, I'm going to be the guardian, they definitely wanted me, there's nothing that really suggests one way or the other what you were thinking. So we often have that conversation about one specific person at a time. You can have an order, right? You can have Tim first, Sally second, Grandma Sue third, but we want to have that clear order, and we want to be able to turn over to the court a very clear set of instructions of what your wishes are, so that really nobody can fight about it, and then hopefully they do just follow what your recommendation was. So that's
and I think that's So I think that's a great example, just going back to the DIY question of how you can answer the question accurately. It can come out in the doc document accurately, but what you don't know is that your intention is not for two people to be fighting over your kid when there's a divorce or some type of separation like that down the road. What you really want is just to make sure at least one of them is going to be next up in line, and those are the kind of things that having a meeting with somebody like Kevin is going to allow the client to realize. You're going to elucidate that.
Absolutely. Yeah, I kind of mentioned I had this conversation this morning, but yeah, I think this is certainly one of the, core aspects of our relationship with the advisors, that we can sort of walk through some of these issues, have these conversations about what do we do to protect the assets for minors, how are we going to kind of translate that into their young adult years and be able to manage it. I do think we're seeing some more examples too with the retirement account rule change, the Secure Act, and the fact that we've got the 10-year rule once they're adults. But if they are still minors, there is kind of a runway, and that can be managed through a trust, which may be much more valuable to them in the long run. If you just name them, the rules still apply. They can kind of navigate that RMD while they're minors and then switch to the 10-year rule when they're 21, but they have to do it. And what are the chances that an 18, 19-year-old that's now in full control of the account is only going to stick to the RMD rule or only take out a little bit to kind of navigate the 10-year rule? Probably pretty slim, right? So again, just making sure everything's back in the trust, even when we hear a lot of the, well, almost my entire estate is retirement account. I have a beneficiary on it, so I'm good, right? And this is one of those conversations around, yes, technically they would receive it. It will go to them. It will be there for their benefit. Someone will kind of watch it till they turn 18, and then they turn 18 and they're in charge. And yes, they can continue to push this out, for the 10-year period under the rules. But again, nobody is looking over their shoulder. Let's put it in a trust. Let's have a responsible trustee in place at least till they turn 30. And then they've sort of had that nice runway. We've navigated all the complex rules with these retirement accounts. We've gotten them through their college years and into a job and a stable career and all of that. And now we can kind of turn over control, or maybe 30, 35 is when they get distributions outright anyway. We kind of have that conversation. But these are the cases again where I think we can really add a lot of value. We just not need to understand a little bit more, especially on the special needs side. So just kind of the other part of the slide here. Actually just reviewing a case today where and I think that this happens a fair amount. There's this sense that we know someone might be on kind of a special needs trajectory in a way when they're 5, 6, 7, but we know a lot more once they're 15, 16, 17, or even young adult, and then maybe they've been officially declared disabled or they're starting to receive government benefits. They didn't necessarily have those benefits when they were younger. And so sometimes we do see people had done planning around kind of, yeah, it's in a trust, someone will look after it. But now we really do need that supplemental needs trust. We need that extra language. We need that extra separation of their assets into a particular and specialized trust for their benefit. So just having those conversations that, yeah, you may have done some planning, or you may have named children way back when the situations were different. So what do we need to do now to kind of address those differences? Um, this is another one kind of on the theme of we don't know what we don't know. So, I think we can all appreciate a client has no power of attorney, right? So they've got nothing in place for someone to step in and act on their behalf. Um, Certainly on the medical side, that can be really problematic. Who's going to make those decisions? For everyone on the call, maybe the financial power of attorney is more salient because it is about kind of trying to get that business done, being able to continue to manage these assets and help everyone out. But all of a sudden, someone needs to be on record to make those decisions or sign off on your investment allocations and changes and trade um, recommendations. So we want to have those things in place, sure. But I think, and we're just as guilty of this as any other firm out there, but we tend to start with simplicity. We tend to start with often with what are called statutory short form powers of attorney. or at least very basic documents that give the minimum or average amount of control, but they don't necessarily add all of the additional types of control that might be important to a particular beneficiary. One I mentioned, I would kind of circle back on this. So, in states where we tend to use a statutory short form, digital assets are not included in that. So that's still something where the states often have that as a separate statute. And in the power of attorney statutes, it's often clear that that needs to be explicitly added to the list of powers if you want to give that type of control. Now, again, that's only lifetime control. Maybe it's still okay that it's in the trust and someone will be able to kind of pick up and manage it, if someone passes away. But there can be just as many cases where we need to be able to access or control some digital assets, and that actually wasn't a power in that what you might consider default power of attorney. So having that conversation, um, helping the advisors recognize the states where we do use the statutory short form first and why we might want to pivot. Um, just kind of keep an eye out for those things because we certainly have plenty of people on the call where I'm sure you've seen differences where, you have a client in one state and the form looks very, formulaic. It looks like a template straight from, the state website. And that's kind of our typical starting point for any state that provides those. And then you may have seen a longer form one where we've kind of drafted every individual power. And we do use that in some of our states as our default, but we can certainly pivot in other states and use that type of form for the clients for which it makes sense. Some of the other kind of classic missing things here, in addition to the digital assets, usually the ability to add assets or update a trust or coordinate with a trust is something that needs to be added. So again, something we might want to consider. I had a recent case where the person was declining in mental health. They were like, oh, we have the power of attorney in place. But again, it was a statutory short form. So we actually can't create a new trust just simply through that power of attorney. So we've got to kind of work through some more complicated planning to get where we need to go. Um, that is something if we had added just the very simple paragraph that says my agent can create a new revocable trust or add assets to a revocable trust, then the agent can kind of pick up and do some of that stuff when the time is right. And it makes the planning a lot more smooth. These are all things just to kind of let us know if there are concerns about that, if there's something that we should be addressing more specifically, and just kind of bringing it to our attention, having that conversation. So it's really degrees, right? So now they might have a power of attorney, but it might just not have enough stuff in it. We want to have that conversation as well so that they're fully, protected. At the same time, I will say we don't always want to include that stuff. We have plenty of clients that say, no, 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 I don't actually want someone to be able to alter my plan. I'm doing my planning now. I want to know that it's going to stay in place, even if I have no capacity in my later years. I don't want someone to be able to change it. So it's
That makes
sometimes
sense.
a thin line that we can't always just say we're going to give you all the powers because then there might be a situation where we didn't want those powers as well. So it's a tough situation. And it's one where we really would value your input and feedback as advisors and people that, really work with their family much more intimately and directly on that day-to-day basis. Um, Nine, I think again, we've probably covered this a number of different ways, but this is really our big value proposition, right? We work directly with you. We really can have these conversations and make sure that we're coordinating things like investment strategies across different trusts, across different parts of the plan. But the most salient one that we see time and time again is that, someone that has an irrevocable trust for their benefit, whether it's a current client or it's something we're setting up for their future children, that has very different tax consequences than what they pay in their own personal income tax. And so maybe let's have a different investment strategy. And the simplest answer is usually if you did a lot of growth assets in their irrevocable trust, and in many of our documents, we do discretionary income and principal, but we're sort of forced to take income out because there's income coming in the trust. We don't want to pay the higher trust income tax rates. Well, if the investment is skewed towards assets that don't pay dividends, or that you don't plan to buy and sell all that often and generate any capital gains, they really can then sit and grow and benefit that next generation in a much more meaningful way than if we just have the same investment plan across their personal assets and their irrevocable trust. And then, of course, the flip side of that would be to do more income based planning in their personal assets, let the income all flow to their personal return. and kind of separate it out that way. So again, we're here to have those conversations, to walk you through it, to, remind you of the different tax consequences, and kind of work as that holistic team here. And then the last one is just, again, we really value that you're going to meet with your clients every year or twice a year. You can kind of stress test the estate plan much more frequently. Not that they need to change it every time, but you can always just kind of have that check in. Beneficiaries still seem right. Everything is still as you remember. Did you buy anything new? Open any new accounts? Helping them with that maintenance. And then also just serving as that sounding board to say, hey, maybe it is time to go talk to Hargrove team and Keven and whoever it may be. Let's talk about, it's been 5 years, it's been 10 years. What does this look like to update the plan now? Because I think we've seen a lot of people coming where they let their plan get really stale. We really want to avoid that the next time around, right? We want to make sure it stays up to date. Life moves fast, people are moving, people, lives are changing, kids are in different locations, all that sort of stuff. So just staying on top of all of that and making sure the plan continues to actually meet their goals and wishes. But yeah, thanks for meeting with us today, Alex. I don't know if we have any other questions or
We do have some questions. I thought I'd just save them for the end here. So first one, how about joint owners with survivorship in a community property state? Will this get double step ups?
So it really can sometimes depend on your custodians, and sometimes it's a great conversation to have with that side of. So if you're working with Schwab or Fidelity, um, in some cases they do want you to say something like joint with right of survivorship community property, or make some reference to the community property if you're going to do it at just the account level. But probably just a great advertisement for, let's put it in a joint trust that clearly states as community property. At that point, it doesn't matter what the custodian's rules are or anything like that. It's going to be clearly in a legal entity that is demonstrated that it's community property, that reflects that language in the document. And then at that point, we know for sure. But yeah, it can vary sometimes by custodians what they consider to be necessary on that account paperwork to say that it's community property. So a good question to ask them too.
That's great. And then next, for putting assets for minors in a trust, how does it work with capital gains and investment income that is received by the trust? Trust tax rates are high. Is the idea to have money distributed for HIMSS provisions to offset the income and the cap gains?
Yeah, so again, our typical first draft is always going to say that lifetime trust for the next generation, kids, grandkids, whatever it may be, is discretionary income and principal for health, education, maintenance, and support. That's kind of our typical starting off point. So what it goes back to is, yeah, there's probably going to be a conversation for all of those trusts every year. All right, this is the income. If we assign it out to the beneficiary, then they're going to pay lower tax rates, but we lose the protection, right? We have to make that distribution out to the beneficiary, and they may not need all of that money. So back to what I was saying earlier, if you do kind of tailor some of the investment strategies so that we just know we're not going to generate all that much income because we don't need it in the trust. Now we don't have to necessarily distribute everything just to save on the income taxes. We can kind of keep it within. But yeah, I mean, there's always going to be some version of a distribution for beneficiaries. I mean, our trusts are designed to be used. We're not really in the business of saying like, let's put it aside and don't let them ever get it ever. Maybe there's a client once in a while that wants that, and we'll have that conversation. But usually, since we're kind of dictating, hey, this is why this is good, and we want to make it flexible for everybody, we do want them to make withdrawals and use the assets. So it's just, again, coordinating. We're happy to have those conversations with accountants, CPAs, whoever else is on the team that kind of needs to run through that, or if there are any issues with 1041s over the years, we're happy to kind of jump in and have those conversations and see what we can do to improve it for the next go round of tax returns. It's something that's going to be an ebb and flow every year, but ultimately, yeah, it's a question of whether we keep it in the trust and probably pay a little bit higher income tax, or we make the distribution out to lower the income tax, but we're losing control over those assets. And was that needed or not?
Fantastic. And then the last question here, I think I can take this one, is related to um, any visual flow charts. So the question asker wants to know, are we going to highlight the named individuals and illustrating how assets flow upon passing, first, second, etc. And the answer is yes. We actually recently, a few weeks ago, probably over the summer, released a new visual guide. We had it for beneficiary designations. We had flowcharts showing, your first executor, your second executor, but we've now added the ability as well to have a visual that's going to show the beneficiary designations, basically how the assets are going to flow through the different levels in the trust. So if you log into your advisor portal with clients, you will see a button in there actually at the appropriate time. Once the legal team's drafted the documents and they've been finalized, you'll see in there that you've got the ability to generate that visual, and then you can walk that through the client. You can walk through the client that process the next year. So you've got some relic, to say, here's what we did last year and here's where things were at, and maybe we need to go see Kevin again, or maybe we don't.
All right.
Good. Well, I know everyone's on here also. At least some of you are looking for professional continuing education credit, which we will be coordinating an email after here for everyone that attended with next steps on that. I really appreciate your time and for the thoughtful questions. And just if you aren't sure where to go to schedule a meeting with Kevin, some of you out there, we've got direct integrations with. You've got an Octatile or Azure or Duo, somewhere where your company has resources, apps that you can log into. You should just be able to tap NetLaw there and you can connect and schedule a meeting. You tap the add client button and 60 seconds later, you're on Kevin or one of his colleagues' calendars there. For everyone else, if that doesn't ring a bell with you, you can just go to netlaw.com and tap login at the top right. If you don't have an account, we will follow up in the email with one of our senior relationship managers who can do a demo for you, get you set up with account. And definitely you can email me directly as well, alex@netlaw.com. Yeah, there we go. One of our relationship managers on the screen there. Schedule a demo. That's mo@netlaw.com. And we will put that in an email as well. Again, everyone, thank you for your time and you all have a great afternoon. Thanks, Kevin.
Oh, absolutely. Thanks.